Keean Bexte here in Vancouver, British Columbia, outside of the province's Supreme Court, where we were in court today to hear a ruling on an application to stay a previous ruling from the courts whereby the daughter of a father was mandated to receive hormone injections. Gonadotropin-releasing hormones would change her body structure, not just changes in genitalia, but broadening of the shoulders, slimming of the waist, cessation of periods, and perhaps permanently an end to her fertility. Now, there's a long saga in this case, a saga that involves parental rights and free speech, not just of the father, who has been silenced, not allowed to intervene with his daughter, not allowed to refer to his daughter as her or she, in fear of being labeled a violent parent by the court and perhaps even arrested, but even his lawyers, who conducted an interview with me many months ago where the lawyer referred to the daughter accidentally as a she, which caused the court to absolutely explode in anger. The justice sent many emails to the lawyer, making him reach out to the rebel, requesting that we take down our videos, implying this insidious idea that all Canadians were restricted from mentioning the daughter in terms of she and her. Absolutely unheard of and unprecedented in Canada. Today, the news is that a stay will not be granted in favor of the father. The father hoped that a third judge would actually stop these hormone injections. Unfortunately for the father, that seems to not be the case today. There will be an appeal later on next month where several judges will hear the father's case again, where the father hopes that the decision will then be reverted. However, the father mentioned to me that many months have passed since the injections have began, and it will likely be too late to save the daughter's fertility, much to the disappointment of the father, understandably. I'm here today with Carrie Simpson, the executive director of Culture Guard, who has been at many of these hearings over the past few months. Here's what she had to say about today's ruling. Now, we just left the court case between AB and CD. Can you tell us what the justice meant when he said he wasn't convinced that the stay would be equitable and actually give justice? He's not allowing the hormone treatment to stop for, I think, 14 to 16 days. Can you explain what that means for the daughter and the father?
It's a very interesting case. It seems that the court is circling the wagons, if you will, protecting the judges, and maybe protecting the judges over the best interest of the child in this case. So what Chief Justice Hinkson did today, and the Chief Justice chose to sit on this case, was he delivered his decision in the stay application. The stay application was to get treatment ceased between now and when the Court of Appeal can hear the case. And he, through his understanding or lack of understanding of issues regarding transitioning for children, felt it was in the child's best interest to just let the child continue. The evidence before the court in this case was that the child was doing well, feeling better after receiving testosterone, and that's natural. The child is being drugged. There's a euphoric aspect to that kind of thing. That judge did not address those issues, and instead just said, oh, well, the child is doing better. So we're very concerned. We're not surprised by the decision today. We anticipated it. There is a short time span. I think the judge said 16 days before the Court of Appeal is heard. That is if the appeal goes ahead. Now, that doesn't prohibit the side representing the mother and the child in this case from now seeking new court dates and those kinds of things. So we'll see really if this does transpire early in September with the Court of Appeal.
Now, I was lucky to be able to live tweet the whole court proceedings today. You can see that at the real Keean on Twitter. The judge graciously allowed me temporary ability to live tweet in the British Columbia Supreme Court. It was very nice of him. But we're going to see what happens here in the future, because the courts have been fighting tooth and nail to have the rebel remove our videos. Anything that refers to the daughter as she or her. Of course, the rebel's not going to do that, because the rebel is here to share the unaltered truth with our viewers. If you want to support us, you can go to rebel.media to see everything that we've been doing to cover this story. Of course, we're not going to be taking down our videos unless a court forces us to with a court order. Unless and until we get that, our videos will be viewable at the Rebel. Now, the father will continue to appeal the decisions made by these courts at the British Columbia Court of Appeal. That will be early in September, and the Rebel, of course, will be there to cover it and live tweet the proceedings as we are able, depending on what that court decides. And all of these videos are available at therebel.media and on YouTube, which you can continue to view and watch if you want some background information. They will be left up as long as we can leave them up. Of course, if a court order comes directly to us demanding that we take them down, we will proceed legally as appropriate to protect our ability to give our viewers the unaltered truth. For therebel.media, I'm Keean Bexte. Hey, can you do me a favor? Can you make sure that you're subscribed to The Rebel on YouTube? It really helps us out. We don't get any government funding like the CBC or the rest of the mainstream media. So when you subscribe to us, it helps us keep you up to date with the latest news.